All right, we're going to get started. Excellent. Good morning, everybody. Oh, that's great. My name is John Hallway. I'm the Executive Director of the Quattrone Center for the Fair Administration of Justice and an Associate Dean here at Penn Law. And on behalf of my colleagues at the Quattrone Center, Dean Ted Ruger of the Law School, and my colleagues at Penn, it's a real pleasure to have all of you here for our fourth annual co-sponsored symposium with the Association of Prosecuting Attorneys, Innovations in Prosecution. This is something that the Quattrone Center and the APA have done together for the past 4 years. And I have to say, you know, when you run a criminal justice reform center, just those words, people, you know, convey a certain, often an expectation about where you're coming from. And I think the Quattrone Center is a little unique in our approach, but I think the APA is as well, and they've been really wonderful partners for that reason. Our approach is what we call a systems approach to preventing error in the criminal justice system. And so while the letters QC do stand for Quattrone Center, we also think of them as quality control. And we try to partner with all parts of the criminal justice system to identify areas for improvement. And so in that sense, yes, criminal justice reform, but really so that the parts of the system can function the way they're designed, and so that the police officers and prosecutors and defense attorneys and judges that work in our criminal justice system can be the kind of criminal justice professionals that they wanted to be when they first took those jobs, and they can serve in the roles that our system intends them to serve and kind of be the best versions of themselves. And one of the things that happens often in criminal justice reform, and not to single prosecutors out, but often prosecutors bear and law enforcement bears a lot of the brunt of the criticism for what goes on in our system. And there are reasons for that that make a lot of sense, but I think as a result they can be very sensitive and hear the words criminal justice reform as an insult. And it really isn't, or it doesn't have to be, right? Yes, there are things that people do, you know, that might be intentionally wrong or negligent, but much more often what we see is good people working hard in a flawed system, and we work to improve that system so that the professionals that operate in it can improve. That means that we're not necessarily being critical, and it takes an open-minded group to understand that, right? To kind of work through that initial reflex. And APA has really been that kind of partner for us. They've been open and engaging. They're dedicated to improving the quality of the system, and they're willing to acknowledge a need for improvement without necessarily seeing that as criticism for the work that has come before. And so we're thrilled to partner with them, and I'd like to turn the microphone over for just a moment to Nicole Parisi, APA's General Counsel, and a big reason why we were organized enough to get all this prepared for you here today, to say a few words and kick things off as well.
Words, John. So as he said, I'm Nicole Parisi. I'm the General Counsel for the Association of Prosecuting Attorneys. For those who have attended an APA event or have been to this summit in the past, you're used to seeing our President and CEO, David Laban, up here. He unfortunately could not make it today, but I know how bad he wishes he could be here. So first and foremost, on behalf of APA, I want to thank John Holloway and the Quattrone Center for their leadership and sponsorship for this event. Really, without them, their generosity, and as I said, John Holloway's leadership, this would not be possible. This is an event we look forward to every year. It's a little unique in the way that we plan it, in that because of the generosity of the Quattrone Center, we're really given a clean slate to create an agenda that really highlights the innovations in prosecution. So that allows us to collaborate with our colleagues and our members and partner organizations to really understand and figure out what are the issues that are bubbling up in the work you do every single day. What are the innovative programs and practices that are being implemented that tackle not only the emerging issues, but issues that this profession has faced for years. And so there's no doubt that the criminal justice system is in a state of reform and innovation right now, which is very exciting. And there's no question that as prosecutors and law enforcement and anyone working in the criminal justice system, that change is happening. And so we're not looking to not change it, we're looking to figure out how we can change it and what are the best practices to implement. And so on behalf of APA, that's what we're trying to do for prosecutors and our collaborative partners. So yeah, we hope the next day and a half can ignite those conversations. We're extremely grateful for our faculty who have put together very thoughtful presentations that I think will help facilitate those discussions. And last, I want to thank all of you for being here. It isn't easy to leave for a day and a half. We know how difficult that can be. So the fact that you prioritize this and you find it important to be here, we really do appreciate it. And really, this wouldn't be happening at all if you guys did not make the time to come here. So I see a lot of familiar faces, but if you have not worked with APA or do not know what we do, please come see me at some point during the next day and a half. I'd love to discuss with you what APA can do to help you or your office. So yeah, without further ado, I'll pass it back over to John to talk about what we're going to be doing for the next day and a half.
Thanks. Okay, so part of the reason that we agreed to start this series with the APA was a recognition that I think is probably not lost on anybody in the room, that the role of the prosecutor has been changing over the past decade, and often in the sense that, you know, the only constant is change. The role continues to evolve even in the 4 years that we've been doing this. You know, I think when we started the center in 2013, smart on crime was still thought of as kind of a novel concept by some. Now I think it's kind of table stakes, and it's hard to approach the prosecutorial role without asking what the utility is of the reforms that we want to put in. When we started the center, one of the situations I think we were in was that you know, there might be a lot of disagreement about what activity we should call a crime, and there's a lot of disagreement about what we should do with somebody who's been convicted of a crime. We decided to plant our flag in the middle of that because we thought that pretty much everybody agreed that we should only punish the people who had actually committed the crimes. I think that's something everybody can agree upon, so we decided to start from where does everybody agree and branch out. Prosecutors don't really have that luxury. Prosecutors have moved, I think, from being tasked with being the chief law enforcement official in their jurisdiction to being the chief leaders of criminal justice reform in that jurisdiction. And as more and more people have become educated about the power that prosecutors have and the discretion that they have, that discretion is both a blessing and a curse. The blessing is you do have the ability to be flexible, you do have the ability to be creative. But the flip side is those areas where we have subjectivity, those areas where we have disagreement, what should be a crime, how should we handle those crimes? Once somebody has committed a crime, what's something useful to do to help that person, to help the victims, and to reduce crime going forward? Those are all areas where the discretion and the subjectivity then become subject to debate. And with debate comes the possibility for criticism, but also the possibility for improvement. And so the antidotes, it seems to us, to the criticisms that come with discretion are transparency, data, and feedback loops. And so just as an example, here's one way to think of how to improve your criminal justice system. It's pretty straightforward, but we rarely do it. Is our criminal justice system awesome? If so, great. But maybe there's something that isn't awesome in our criminal justice system, and I'm just whiteboarding here. Maybe there are things that we can do better. So what's the answer? Well, let's do something different and see if it works and talk about it. And that's why meetings like this are so important. What you're going to hear about today and tomorrow are examples of prosecutors who are working hard in their districts to unify opinions, to understand what's really going on in their jurisdictions, and to take control of and lead change in the most important societal issues that we have today. They're running risks because they're taking risks and making change. And something that I think they will be helping all of us do today is to be more transparent about the need for that change, methodologies that are working, sharing that information, and constructing those feedback loops that are the only way that any system of human interaction has ever gotten better over time. So we're looking forward to that conversation. We've got a great show for you tonight. And we're going to start with my colleague and good friend Tom Hogan, the DA in Chester County, Pennsylvania, who's going to talk about the Brady rule, in particular how the Brady rule deals with impeachment information and law enforcement. One of the really big issues that's been happening, certainly in Pennsylvania, very, very publicly in Los Angeles and lots of other places nationwide, are the issues of how do we deal in a pretrial criminal discovery context with police officers and other government officials who may have instances of allegations or proven misconduct in their past in a variety of means, and the obligations to turn that over as potential exculpatory material under Brady and GIGLIO. We'll have a pronunciation guide. And so Tom has been leading the charge both within his office and statewide on implementing best practices for that. We're thrilled to have him here to talk about that. Ladies and gentlemen, Tom Hogan.
All right, no chance of me staying behind the podium, so let's get going on this. GIGLIO. Now, the last time John asked me to come down here and speak, it was on officer-involved shootings. So I really appreciate the fact that he asked me to come down and speak on totally non-controversial topics. So, but GIGLIO, the worm in the apple. The apple being, obviously, the criminal justice system. The worm being lack of credibility of any police officer who's testifying, which we completely rely upon as prosecutors. So we're going to talk today about how do we discover this lack of credibility for police officers, and then how do we disclose it? How do we deal with it? So as we do this, two things are a given that you need to keep in the back of your mind throughout this discussion. The first is that police unions hate GIGLIO with an unrestrained passion. They will fight it tooth and nail all the way. They have sued people in Pennsylvania, they sued people in New York. That is the new trend about GIGLIO. So they do not like it. And we will talk about that and the reasons they don't like it a little bit. Yep. And the second thing that you need to keep in your mind is that as prosecutors, it is your duty to enforce it. So you are going to have to go head-to-head with police unions about this. And it's not going to be a pretty fight. But it is your duty, your constitutional duty, to enforce GIGLIO. All right. I am the head of the Best Practices Committee for the Pennsylvania District Attorneys Association. And we have come up with a GIGLIO protocol which we will be rolling out statewide sometime in the next month. It's not perfect. I will learn things from you here today that I will take back and I will tweak our protocol. So I want to hear what your reactions are to our protocol. But I believe it's one of the first states to actually adopt it statewide and roll it out so that both prosecutors and the police all know what the rules are, so that everybody will understand exactly what we're talking about. And what we're going to do here today is we're going to go through the basic issues, and we're going to do some hypotheticals. And we'll see if we all agree on the hypotheticals that this is or this is not GIGLIO material. Now, let me start by asking this. How many of you lie at work? Right? Nobody's going to raise their hands. How many of you know people who lie during the course of their work? Yeah. All right? All of us do. Well, guess what? Police officers are people too. So in the course, in the cohort of police officers across the United States, some of them are going to have credibility issues, just like the general population. So the trick is to be able to figure out who those police officers are, because let's face it, when a sales guy is selling you a car and he tells you this is the deal of a lifetime, that has different ramifications than a police officer taking the stand and saying, so-and-so did this, and as a result, should go to prison for the rest of their life. So this is a very high stakes proposition that we're talking about. All right. Now, one of the first things that I wanted to cover, though, in all of this, is the pronunciation. It is GIGLIO, all right? I have been a federal prosecutor, I have been a local prosecutor, I have been a criminal defense lawyer. It is Giglio. It is not Giglio. It is not Giglio. John told me that somebody on his staff asked if the Gigolo presentation was still going to be on today. And my answer was maybe a little bit, but that's not the pronunciation. It's Giglio. If we get nothing else out of this, let's spread around the nation that the correct pronunciation is Giglio. All right. Now I'm going to need 4 volunteers. 4 volunteers, because as we go through the hypotheticals, 2 of you are going to act as union attorneys, police union attorneys. 2 of you are going to act as the ACLU. So do I have volunteers, or am I just going to have to pick you out? Come on down. Oh, come on down. Come on down. And you sat too close. You sat too close. I warned you.
You can't punish people for that.
You sat too close.
I'm a retired corporate lawyer. I'm not
Oh, okay. Fair enough. Fair enough.
Well, I actually work at the ACLU, so I'm not sure if that corrupts the
That's perfect, because you are going to have to be the police union lawyer. All right, go ahead and have a seat. We've already got this set up. All right, you guys are the police union lawyers. You guys are the ACLU. As we go through the hypotheticals, confer with each other, and you guys will then pick one of you to take the position that you're going to take, all right? All right, so let's start. First question is, why is Giglio exploding right now? Because the rules have been in place forever, right? BRADY, 1963, prosecutors have to turn over exculpatory evidence. Giglio, 1972, that includes impeachment material. And that impeachment material includes all witnesses, not just civilian witnesses. Bagley, 1985. What is impeachment material? Anything that could reasonably result, has a reasonable probability of resulting in an acquittal, which obviously means 2 different things if you're a criminal defense lawyer and you're a prosecutor. Depending on which point in my career you ask me for a definition of that, I would give you 2 different things. And then in Pennsylvania, we actually have a case called Palermo, a Pennsylvania Supreme Court case that explicitly says a prosecutor has the discretion to decide if a witness is so lacking in credibility that they will not be called by the prosecution. So we actually have a little ace in the hole in Pennsylvania. All right, but why is, since these rules have been in place forever, why is Giglio exploding now? 2 reasons. One is progressive prosecutors. All right? And progressive prosecutors are pushing this out and making it a very public issue. And that's a good thing. Whether you consider yourself to be a progressive prosecutor or an old-fashioned law and order prosecutor, you know what? Making sure that we get the truth out from our police officers is incredibly important. So all prosecutors everywhere should agree on that. The second thing that is happening and is driving this out is federal prosecutors are leaking back into state DA's offices. I was in the U.S. Attorney's Office and then became the district attorney in Chester County. Well, if you're a federal prosecutor, Giglio, you're a franchise owner if you're the U.S. attorney. Right? Justice, Main Justice sets up all the programs. Giglio is part of it, so you automatically get it. If you're an elected DA, you may not have had any training at all on anything like this. So you don't have any idea walking into this, what you're getting into. So, but as federal prosecutors leak into the state system, they are bringing Giglio with them. And that's helpful as well. Now, there was an old story about Bear Bryant that may explain why this is just exploding now. And Bear Bryant wasn't very happy, legendary Alabama football coach. He wasn't very happy with one of his linemen. And he said, "Bubba, what is it with you? Ignorance or apathy?" And Bubba looked up at him and said, "Coach, I don't know and I don't care." And there's a little bit of both of that going on. The ignorance is people simply did not know about Giglio. And I'll give you some very specific examples. when we were putting together our Giglio protocols, there are 67 DAs in Pennsylvania. And as we were putting them together and consulting with everybody, one of my colleagues pulled me aside and said, look, this is great. We clearly have to do this. But let me tell you right now, out of the 67 DAs in Pennsylvania, 60 of them are going to have no idea what you're talking about when you start talking about this. And he was right. And then we looped in the police chiefs associations and the unions when we were coming up with these protocols. And we have over 1,000 police departments in Pennsylvania, something like 1,200. All right, it's ridiculous how many we have. But one of them pulled me aside and said, yeah, absolutely, we have to do this. But out of the 1,200 police chiefs that we have, 1,100 of them are going to have no idea what you're talking about. So there's the ignorance part of it. The apathy part is that people don't really want to grapple with this issue. It's an ugly issue. So people want to look the other way. And people have sort of had a very informal system in place previously, which is, yeah, I know which one of my cops I can call and not call, but I don't keep a list. And I don't really know, I just know that that guy I can't call. And that informality of that system, while it may have worked 20 years ago, 30 years ago, isn't going to work going forward. So ignorance and apathy has driven it. Progressive prosecutors and federal prosecutors coming into the state system, and general awareness is why it's exploding now. All right, so let's start with what is Giglio material, because that's where it has to start. By the way, our protocol, we have shared it with the Quattrone Center and APA, and it is available to you. I have given you the Chester County protocol. The PDAA protocol has not rolled out yet, so I can't share it publicly yet, but I'll give you a hint. I wrote the Chester County protocol, and I wrote the PDAA protocol, so outside of 2 paragraphs getting flipped, you're going to see the same thing. All right, so feel free to take it, feel free to criticize it, feel free to copy it. All right, what is Giglio material is the very first question. How are we going to define what Giglio material is? Well, the definition, first of all, anybody in here, name the Supreme Court case that lists all the different things that are Giglio. There's not one. All they did was they gave us Bagley and said, you figure it out. Anybody name the Pennsylvania Supreme Court case that lays out the Giglio categories? There's not one. It's crazy. They have given us all this stuff and said, yes. Figure it out. So, to any judges who are out there, somebody please take this up and give us all of the categories so we will know. Because it varies from state to state what is considered Giglio. What is considered Giglio in California is not Giglio in Illinois, which is a problem. We need uniformity. All right. So, Giglio is a little bit like this platypus up here. We're not quite sure exactly what it is. So here's how we defined it in our protocol. We said anything that is considered Giglio material under any cases, specifically including but not limited to 4 categories. Dishonesty in the line of duty, anything in the line of duty that affects the credibility and integrity of the prosecution or the investigation. Obviously, crime, if you have been charged with or convicted of a crime that would disable you from acting as a police officer. And the 4th one is racial bias. Actually, any bias or prejudice against any group, because that needs to capture anything. So, some people asked us, why didn't you come up with a long list? I actually was talking with who was then the superintendent of the Baltimore Police Department, Gary Tuggle, who had a very long list. And I said, Gary, what we're actually trying to do is we want the police to focus on the most likely things, and those 4 are the most likely, and then we want them to come back to us and ask us questions about everything else. Because we don't know, and we're going to have to define it case by case outside of those 4 categories, and we want calls coming in. We don't want the police to have to try to make those calls on their own, because that is an invitation to try to get around the rules. So that's why we came up with 4 general categories and a catch-all, which is anything that could be giglio. All right, so we are intentionally vague there while giving them some of the 4 things that are most likely to show up. Now, let's start with hypothetical, and we'll see how we do. All right, off-duty bar fight. Police officers in an off-duty bar fight tease somebody up. Police union. Is that giglio material?
Can we discuss it?
Sure, you guys can discuss it for a second, and then I'll be talking to the ACLU over here.
Is this a mute button or what's?
You're hot.
You're hot. And there goes John Hallway. It was fun to be an associate dean. All right, bar fight. ACLU.
It's definitely a potential crime, and it definitely can, a bar fight is obviously it could be an assault, God knows what else, and the integrity of the prosecution of the criminal process is gravely in danger if this officer is able to continue without this disclosure of this activity.
You're hired.
Bar fight. Police union.
Well, first of all, the prosecution's use of the word potential is the problem here. There's lots of reasons why there's a bar fight, and we have no idea whether someone else started the fight and the police officer or officers responded in self-defense. Secondly, police officers have due process rights. I don't believe that in the hypothetical, I don't even think they were charged with the crime. Let's say they were charged with the crime. There's certainly no resolution of that.
They were not charged with a crime.
Okay, that's helpful to our cause. Secondly, I have no idea whether there's going to be an internal investigation begun outside of the actual criminal justice system into whether the police officers involved in the bar fight did anything wrong, meriting some kind of discipline, suspension, etc. And also, what does this have to do with integrity of a prosecution? It's not even connected to any particular prosecution. And let's say, does it have to do with the credibility of the officers? I don't understand why a fight in a bar would have anything to do with if a police officer testified, whether he or she was telling the truth about any particular matter.
All right. 2 presentations that sound very much like you would get from police unions and the ACLU. How many of you think an off-duty bar fight without any charges should be considered giglio material? All right, couple, not many. This actually brings me back to one of my favorite things that I tell young prosecutors, which is 2 guys fighting in a bar is not a crime. And by the way, it's not a terroristic threat when one of them says, I'm going to kick your ass, because that always precedes every bar fight. So, the general consensus has been that an off-duty bar fight will not constitute giglio. There actually is a case out there from New York where somebody did try to put giglio down on it, and a court said, no, that's not going to work. But let me add this. Same category, but the off-duty officer during the course of the bar fight, it was a white officer, and he was fighting someone who was African American, and he used the N-word during the course of the fight. All right, is that giglio?
Absolutely.
ACLU?
Absolutely, without question, racial bias. And I still stand by my previous statements.
You sure you don't work for the ACLU? Police? No.
The officer in question still has due process rights, and we have to go through a fact-finding that offers him an opportunity to, him or her, an opportunity to rebut whatever statements folks are making about their racial bias.
Well, we did that, and by the way, the whole thing was caught on video and audio, and he used the N-word.
I'm gonna have to confer with counsel on
All right, how many of you would agree that an off-duty officer who in a bar fight uses the N-word, that constitutes giglio and has to be turned over? Right. That's going to be dead on racial bias, and we're going to have to turn that over. Absolutely, that's going to have to be
What if the
reported.
defendant's not black?
What's that?
What if the defendant is the same race as the police officer?
Why are you jumping ahead to the next part of the hypothetical? Both the police officer and the gentleman he attacked, or got into a fight with, are African American. Aha! Now, police union.
Unfortunately, we know that some black people use the N-word. And the fact that a black police officer uses the N-word against a black assailant, or whatever you want to call him in the bar fight, does not necessarily show racial bias. We need to learn a lot more about the circumstances and maybe the background of that officer before we can automatically assume that it shows racial bias.
So if I'm of Irish descent, if I've got a guy and I'm whacking him and calling him Paddy, that's going to be okay?
Again, I'm no expert in Irish people. I'm sorry. But we are the police union. We're here.
I was going to say, you're in the police union, you're not an expert on the Irish?
That's a good point. Maybe the police union needs another lawyer. But once again, when you have a bar fight, as you said, the circumstances vary tremendously as to what started it, what happened, who said what, and we just need to learn more before we automatically assume that using racially derogatory terms means that someone is either a racist or is biased against particular groups.
All right, ACLU, you're up.
Because of the role I'm playing, I'm just going to say yes. But I think you would want to know more information if there's a trend.
What more information do you want to know? You have an African-American civilian, an African-American officer who is off duty, and during the course of the assault, during the course of the fight, the officer calls the other person the N-word.
Well,
Make me an argument.
I think, number one, we stick by our previous statement that if you're in a bar fight, and even if you're not charged, it's, in my jurisdiction at least, that is a crime to get in a fight at a bar, to get in a fight in any public place unless you're in a UFC ring. Secondly, obviously, we would want to hear a recording of how the word was used, and that would give us some degree of knowledge about how much racial bias is being used. However, that word in and of itself, because of the history of this nation and the history of that word, it should be that should be a disqualifier if that is used in a public arena by a police officer.
All right. How many of you think that this particular hypothetical should constitute Giglio material? How many of you think it should not?
No,
All right.
What if the defendant in the case is white? In the underlying cases?
We could keep flipping these around.
No, but why would it matter then? I mean,
Why would it matter? That's part of the beauty and difficulty of Giglio, is making these judgment calls. The answer to this is nobody knows if this is Giglio. Nobody knows. All right? Under the case law, nobody knows. Is there a reasonable possibility of acquittal if that information is turned over to the defense? Who's a defense lawyer in here? I would say that, yeah, if I'm a defense lawyer, 100%. If I'm a prosecutor, I'm going to say, no, I don't think so. All right? That is the problem with Giglio. It gets very complex at times, and that's part of the things that we are grappling with, which is why we wanted to take this out to that next level in the hypotheticals. All right, so that's how we define Giglio. We define it as 4 major categories, but anything else that could be, because we get into these complex questions that we need to talk about within the office. So, all right, now we know what Giglio is. How do we find out about Giglio? How do we find out the information, the basic information that we need? How is Giglio reported to us? I love the J'accuse by Émile Zola, right? What was it? French, right. The Dreyfus affair. And an individual, a Jewish officer in the French army was drummed out, and it was based on the fact he was Jewish. It's a great example of Giglio. But how do we get the Giglio information? Two main sources. You've got the police, and you've got prosecutors themselves in the DA's office. You've got the lawyers. You may actually have defense counsels reporting it to you, to the prosecutors. But let's talk about police first. Because the issue that we struggled with getting the issue from police is, okay, do we sit down and go through everything about this police officer, their entire file, and have somebody go through all 8,000 police officers in the county and go through every single file and every single written opinion in their background and develop a Giglio profile on them? Or do we tell the police, here's the Giglio definition, and you tell us about it. You report it to us. And where we eventually came down was, look, Giglio is a part of BRADY. It's discovery. How do we do discovery every day? We tell the police to give us the discovery. And is it possible the police sometimes holds things back or just forget? Yeah, it's possible. In Chester County, we have open file discovery. I'm happy to say that in 8 years as the district attorney, we have never had a finding of a BRADY violation because a prosecutor intentionally withheld something. Because if it's in our file, it's in their file. I can think of 2 occasions, though, where a police officer forgot to turn something over, and we ended up with a BRADY violation. And either we had to take a continuance in the trial mid-trial, or we got a mistrial and had to try it again. That'll happen. But the basic function of reporting from the police to a prosecutor's office is the same. So we put the burden on the police and said, report it to us. There's also a practical aspect to that, which is if I take 8,000 police officers and review everything about them in their files to produce a Giglio list, you know what I'm going to have to do at the end of the year? I'm going to have to go back through 8,000 files all over again. And it's not just in their personnel file, by the way. It may be in an EEOC file. It may be in a court decision. It is a huge, vast undertaking that if I took my entire office and just had them do that all year and not prosecute any cases, they probably still wouldn't be finished by the end of the year. So we treat it like regular discovery. We tell the police to turn it over. What we found out, we were worried, are the police going to hide it from us? What we found out was, no. The police chiefs, the command staff, were 100% on board with turning this stuff over because they know who their problem officers are. And they want us to know about it. We actually found out there was a problem of over-disclosure. Because if you think about this from an employment perspective, some of the chiefs were sending us Giglio stuff that they considered to be Giglio material and saying, we would like you to put this guy on a do not use list so I can fire him. And we had to say, look, this ain't Giglio. All right, the fact that he didn't wear his hat on a traffic stop, that ain't Giglio. He's not going on the list because of that. But we did find that the police chiefs and the command staffs were very open and very receptive to turning this stuff over. Now, is there the potential for stuff being hidden? Yes, there is. Just like there is in regular discovery. If some police department wants to actively hide things from prosecutors, they're going to actively hide things. And you know what? It's going to get found out sooner or later, and then that case is going to get flipped over, and the prosecutor and the police are eventually going to have problems, personally and professionally. So, in the ordinary course of business, we treat it like regular discovery. We ask the police to turn it over to us. We tell them what the definition is. We ask them to turn it over. And in our experience, there has been over-disclosure, which is a good thing. And then our prosecutors, if they see it themselves, if they see an officer testifying and they notice it doesn't match up with his report, if they notice that a report has had something added to it afterwards, then they bring it in. We also listen to defense counsel. All right, you're going to hear a lot of yelling and screaming if you're a prosecutor from defense lawyers about this cop always lies, and you hear a lot of that. But you've got to listen to it and sort through it and see, because sometimes it's correct. All right, so now where does that information go? Does that go to you as the DA? No. We have it sent to the first assistant. We have it laid out as it goes to the first assistant or their designee. Why? A couple of reasons. Practically, the elected DA, whoever the boss of the office is, the Commonwealth's attorney, the U.S. attorney, they don't have time to deal with all of those issues. Second, you need one person who's handling it because you need consistency across the board. Third, as a political matter, if you are in an elected position, being the GIGLIO officer is a remarkably unpopular position to be in. And there is an old saying amongst elected DAs that if it's good news, it comes from the DA. If it's bad news, it comes from the first assistant. And the chief of staff is there to keep the beer cold. All right? So that first assistant is actually going to have to stand in there and give the bad news to people of, you are on the GIGLIO list. Now, the other reason for it is because, and we'll talk about this a little bit later on, is we do reconsiderations of GIGLIO. And we want the DA to have fresh eyes to reconsider if a GIGLIO call has been made and an officer is appealing it. And we all know judges, and have you ever asked a judge for reconsideration of the judge's own ruling? Right? How often have you been successful with a judge reconsidering their own ruling? You don't get that because it's not fresh eyes. So there are both practical and political reasons to designate somebody else in your office as the GIGLIO officer. All right, so that's how it gets reported. Now let's try a couple more hypotheticals. All right. 3 police officers answer a call for a potential fire in an apartment. They walk in, there's drug paraphernalia all over the place, just like bongs and stuff, and then there is a lockbox sitting right there. The sergeant is one of the 3, and he says, all right, we all know that the drugs and the money are in the lockbox. All right, we're going to need a search warrant. I'm going to step outside, I'm going to call the DA's office, and we'll get a search warrant going on this. In Chester County, you have to have approval from a DA for a search warrant. So he says, and by the way, don't touch that lockbox while I'm outside. He walks outside, calls, comes back in, the lockbox is open. And the officers say, oh yeah, I tripped over it, and the drugs and the money fell out. And the sergeant says, what? And then the next day, he calls them in and says, what really happened? And they both say, all right, we opened it up just to see what was inside. Okay. ACLU.
Clearly dishonesty there, so it needs to be disclosed.
Clearly dishonesty. What else besides dishonesty do we see in there?
The integrity of the prosecution of this actual case is in jeopardy because of this illegal search.
We have a knowing violation of the Constitution, right? An intentional violation of the Fourth Amendment.
Also, their cover-up story was not believable, and that they could have done a better job with that.
Right. So we've got lying. We've got an intentional violation of the Constitution. We also have. What else do we have? Gentleman wearing a badge.
I wish I was paying attention, sir.
Oh, okay. What else we had was a failure to follow a direct order.
Oh, of course.
Failure to follow a direct order of a superior. How is failure to follow a direct order treated?
Termination.
There you go. All right. By the way, we have 2 of these cases currently in Chester County. All right. Police union?
We have to keep a straight face.
Yeah.
The police union defended both of these guys, and I'll tell you the results in a second, but
I'm curious what the argument was after we made that.
Yeah, so we think that we need more internal process to determine where exactly the misstatement here was. We also, I think, we didn't discuss this just now, but I think we also want to encourage police officers to come forward when they have an opportunity. We want them to have candor internally, and so if there was no harm, no foul here, and we concede the constitutional violation such that it doesn't mar the prosecution itself, I'm not sure that we have enough to say that this officer necessarily lied if he came forward right afterwards. So between that and needing some more internal process, needing a third party to come in with fresh eyes and determine, was this a lie, was this a misstatement, I think it's fair to give us more time here.
Wow, going very much from working for the ACLU to becoming a police union lawyer, like that.
Follow the money.
And those arguments were very much like what the police union made, although what they overlay it with is very much and he's a really great guy, and it's really hard to get good police officers these days, and give him a second chance, would you? All right, how many of you think that scenario is Giglio? How many of you think it's a terminable offense? All right. Anybody think it's not Giglio? All right. We told in both instances, we were like, absolutely, it's Giglio. It's not even close. Both police departments terminated the officers. And in both cases, arbitrators put them back on the job. All right? Just so you know what we're dealing with. And one of the arbitrators actually, in a prior case that he issued about 2 months before that, in the same scenario, not the same case, but in the same scenario, upheld the termination, but then 2 months later, overturned the termination. Same arbitrator, right? The arbitration is a huge problem for us in the Giglio process, because now all of a sudden you've got this guy who is back on the job, and he can't do a darn thing. You think any of those people are people we're going to call to the stand? Absolutely not. And the arbitration process is killing us here in Pennsylvania. All right, second hypothetical. Police officer X is in your department, and he's married, and all of a sudden a young woman shows up one day. She's an adult, but she says, police officer X lied to me and said he wasn't married, and we've been having an affair. Police union?
Well, first of all, this is not in any way in the line of duty. Along your principles, it has nothing to do with the particular case, so it cannot affect the integrity of the case. Third, as you said, police officers are not perfect. Show me one person in their personal affairs who doesn't lie at various times. Of course, it was not under oath. So if we're really going to hold police officers to a higher standard than we hold everybody else in the room, then no police officer could ever testify in any case under any circumstances.
ACLU?
Well, we think the office needs to investigate in more detail to figure out if this wasn't the course of duty. Was this someone that they interacted with through?
Not in the course of duty. It's not a CI, which of course would present a whole different, it's not a witness, it's not a victim. It's just totally a random civilian.
This is proof of dishonesty. We believe this young woman that's come forward. And if we have proof that this is dishonest, and the policy, the Giglio policy is that, and should be, that any dishonest acts indicate that this officer is dishonest, then this is Giglio material, and it should be disclosed.
Can I add one thing?
And this is usually how it goes, back and forth. Absolutely.
Well, we know as lawyers that we have ethical rules that prohibit us from making misrepresentations in the context of a case. I know of no ethical rule that says that any time a lawyer lies outside his job in some personal matter, that that's cause for discipline.
Okay. All right. How many of you think the lying about the girlfriend, about the wife, is Giglio? All right. And the rest of you do not. All right.
I'll say he got his just desserts anyway.
By general consensus of prosecutors across the nation, that does not constitute Giglio. It is off duty. It has nothing to do with their duty status. And we also fall into a couple of other things, which is everybody lies a little bit in their personal lives. And the other thing, and again, gentleman with the badge can probably confirm this for me, if we enforced that as GIGLIO, we wouldn't have any police officers left on the street. So that is not generally considered GIGLIO, but you begin to get into some of the arguments that you hear on all sides, and these guys are really doing a great job of coming up with the arguments that the unions and the ACLU comes up with on these things. All right, next issue is we've defined GIGLIO. It's been reported to us. Now, the next question for us is going to be, how are we going to review it? And review by the district attorney's office, look, some things are obvious, right? Some things are in writing, and there's no way around them. But we notify the officer involved, you are under investigation for potential GIGLIO material. We do it in writing, and we tell both the officer and his commanding officer, his chief, his superintendent, whatever it is, to let them know that they are under investigation. Why do we do that? Because we want them to come in, and if they want to tell their side of the story, have an opportunity to tell their side of the story. You don't always get straight information. You guys all know that. When you get reports, you don't always get a full report. So you give the person an opportunity to come in. They can do it in writing. They can come in with a lawyer. They can come in with a union representative. We don't really care. Now, are there exceptions to us putting them on notice before we put them on the GIGLIO list? Yes. Let me give you a couple of ones that the union leaders came up with for us. One, you find out from a wiretap that somebody is dirty, that one of your police officers is dirty. Are you going to go to them and say, hey, guess what? You are on a wire in a drug deal, and we're just putting you on notice that we're investigating you for GIGLIO? Obviously not. All right? You're just going to, in the prosecutor's office, put them on the GIGLIO list and take care of it that way. We've also had instances where a police officer has lied directly to the district attorney. And when that happens, you get into the judge and reconsideration issue. And if you're going to lie directly to the district attorney, you're just going on the list. That's the way it goes. So, and there are other ways that you will find that you will make that exception. But in general, you are going to put them on notice and have them have an opportunity to come in and tell their side of the story. All right, now I'll give you a hypothetical. This is the Rogue Police Department hypothetical. In your county, there is a written order from the district attorney that says in the case of an officer-involved shooting, the department, the commanding officer, has to immediately notify the district attorney, and an independent agency does the investigation. All the shooting agency can do is freeze the scene, close it up until the independent agency gets there. Rogue Police Department does not like that fact. They don't like anybody else coming in. So what they do instead is for 4 hours, they call in all of their people from all over the place, set up a perimeter, start doing the investigation. They let a 18-wheeler drive out. They let a different 18-wheeler drive in. They spirit away the 3 shooting officers and get them out of there with union representation, and they disappear. And then eventually they call the DA's office after all this has been done. And when the commanding officer for the scene is asked, why didn't you call and what are you doing? Their response first is, well, I didn't have the phone number. Now, the phone number is written in the policy. The second, and the second thing, when it is pointed out that the phone number is written in the policy and that you can call police radio to get hold of the district attorney, the second thing that comes up is I had a lot of other things to do. A lot of other things to do apparently consisted of bringing in his entire department and letting the 18-wheeler out and letting the 18-wheeler in and totally banging up the scene and getting the shooting officers out of there so they couldn't be interviewed. GIGLIO?
GIGLIO and criminal investigation by an independent agency.
Okay. Why?
well, for one thing, it's potentially a crime, it seems to me. It could be.
Getting very close to obstruction of justice, aren't we?
Yeah, and, you know, it's not complying with orders from the, you know, directly non-compliance with orders from the district attorney's office. You can't work with an organization, or you cannot work with a group of people that will not work with you and will not follow the policy. So it will directly impact any potential, any potential liability that the officer had, and any potential, if this was a justified shooting, we're never going to know. So this entire scene is destroyed. If this entire episode is destroyed, any credibility in the entire system. So it's definitely Giglio, and it's probably a crime.
Well, first of all, the DA's policy is just a policy. We don't know of any legal requirement that it be adhered to. But let's assume there is.
Well,
let's assume it is.
in Pennsylvania there's a statute that says the district attorney is the chief law enforcement officer of the county.
Let's assume that. Well, I'm sorry.
For other reasons, but yeah.
Let's just say that that's out there. Just call me crazy.
I'm sorry, it's not an assumption, we concede that. Secondly, the scene was a problem in the sense that if we had to freeze it until some independent investigator came in, it would have consumed a hell of a lot of our resources. And who knows how long it would take. This didn't happen indoors somewhere where you could lock the room. It happened in a public place. But the other problem is that the policy sweeps very broadly. What are we going to do? Assume that everybody in the department is, quote, guilty of doing something wrong in the policy? Does that mean that the DA's office can never use any of the officers as witnesses in this? Let the independent investigation occur. We're sorry that what happened, and let the independent investigator determine who's at fault amongst the police officers who were there, so we don't tar and feather everybody and there's no guilt by association.
And the only question is about the commanding officer now, not about anybody else.
Well, the commanding officer, I assume, is rarely a witness in any kind of case because he doesn't work cases, he just commands officers. So,
In this case, it wasn't a chief, it was the actual commanding officer, was the head of criminal investigations.
okay. Well, again, let the independent investigator determine what culpability that commanding officer had other than not following the policy of the DA's office.
Okay. And what if you eventually find out that the commanding officer, that the answer that you expected to get was, I was ordered not to comply with your policy by my superiors?
Then he followed a direct order, and then the independent investigator has to look at the superior officers.
Interesting, right? Because then the superior officer's got a problem.
By the way, I assume, because I'm no expert on this, that the police union deals with people who are sort of line officers below the rank of supervisors, so the police union wouldn't even be out there to defend commanding officers and supervisors, or am I wrong? You know more about this than I
The
do.
police union will cut it off once you get all the way up to the top, but a commanding officer of the scene, who is simply the head of the criminal investigation unit, is certainly going to be defended by the union. So how many of you think that scenario is Giglio? All right, anybody who thinks it's not? All right, tell me why.
I think it's a great example of institutional arrogance, but I don't see the dishonesty. I don't see the illegal act. I don't see the elements that you described as being the foundation for Giglio.
Didn't have the phone number, clearly has the phone number, and I had a lot of other stuff to do.
Yeah, absolutely institutional arrogance, but
But aren't those lies?
that's a reach to me.
That those are lies? And this is where you start to get into the nub of it between law enforcement and prosecutors. The prosecutors were like, that's clearly a lie. You've got to be kidding me. And it's very close to obstruction of justice. The law enforcement, they're like, well, I don't know, could have been. But that's the exact arguments that get raised. So that's the sort of things you're running into with Giglio. And yes, the institutional arrogance of it is a problem as well. That's more of a cultural issue, and you can't fix culture through Giglio. But all right, So nicely argued on both sides again. All right, so you found out about it, you reviewed it, you've given them their opportunity to come in, and now you have made a decision that yes, well, first, if you make a decision it's no Giglio material, we put it out in writing to them, we've reviewed you, there is no Giglio material, so now we have completed the loop in their file that there is no Giglio material, which is important for them going forward because they had a letter saying we were investigating for Giglio. Second thing we do is if we do find Giglio material, we have two categories that you fall into. One is do not use, and the other one is mandatory disclosures or use with caution. The do not use is we just are not going to ever call you. You will not be used as a witness. You cannot be the affiant on a complaint. You cannot be the affiant on a search warrant because we will not use you. That usually is tied into dishonesty. And the response that we got back from some of the police unions was, well, I mean, one lie, how much could one lie really make a difference? And like, one lie really does make a difference when you're prosecuting a case. Any of you who have prosecuted cases know if one of your crucial witnesses is up there and gets caught dead on in a lie, the best you can hope for is a mistrial and teeing it back up, because you're usually just going to get an acquittal. The other thing that we use that always strikes home is one lie doesn't matter? Okay, let's run back to the OJ case. There were a lot of problems with that prosecution. But remember Mark Furman saying, I never used the N-word, and how much time got dedicated in that trial to that one lie, and how much that can blow up? One lie really does make a difference. And we tell the cops, don't lie. Whatever you're talking about, just tell us the truth. Those guys who kicked over the lockbox, it was marijuana and a couple of $100. All right? It would have been at most a probation case to the extent it wasn't just in a diversionary program. And they just put their careers on the line over it. Just sit there and wait for the search warrant. If you did kick it over, say, I kicked it over, Sarge. And when I kicked it over, I realized I screwed up. Then we have a Fourth Amendment violation, sure, and we're kicking the case out. But at least you didn't lie about it. So lies are extremely important. So the do not use is one category. The second category is, yes, we will use you on a case-by-case basis. We are obviously, if anybody is on any of the Giglio lists, either do not use or disclosures list, if they are called by anybody. And that means that if they're called by us or if they're called by the defense, all that Giglio material is going over. Because that's what our requirement is. Yes, sir.
To what extent in your discussions with the, I guess with police chiefs and unions, did you hear that they would, depending upon whether someone was included on a Giglio list, that they would assign them differently based on that?
All the time, which is, yeah, the question was, how often did we hear from the chiefs and the unions that if somebody's on the Giglio list, that the police department has to make allowances in their assignments of that person? And the answer is all the time, which is why we say that when we make that decision, we send a letter to the officer and the chief. And we tell them that you are on the Giglio list, and you're on the Giglio list in this category, either do not use or disclosures list. And what does that mean for you going forward? Because the chief, obviously, has to decide. You can't assign that guy to your crime scene forensics team and have him doing homicides if he's on a do not use list. Now, how seriously do we take this in Chester County? We had a death penalty case in Coatesville where the crime scene forensics guy, in between the time of the homicide and the time of the trial, got caught stealing money from his own union and charities and hit our do not use list and got charged by us. And we didn't call him at trial in the death penalty case. We just worked around it. We had to have other people come in and testify to what was found. And if there were gaps, there were gaps. But there was no way I'm running a death penalty case all the way up through the system with a Giglio do not use guy in the middle of the case.
Did you disclose that you had a Giglio do not use officer involved in the investigation?
Yep. I mean, it was hard to miss because it was on the front pages of the paper that we had arrested him. It was hard to miss, but absolutely, we disclosed it. And what happens here is, just because they're on the Giglio list and you're in a disclosure mode, it doesn't mean that that's coming into trial. Sometimes it will, sometimes it won't. If it's something that is totally unrelated to the trial, the issue of the trial, then you're going to make a motion to exclude in limine, and you're going to argue it out, and you're going to have it, and the judge will take it into consideration, and sometimes they'll throw it out, and sometimes they'll let it in. But that's the process that we go through every time you've got to deal with that issue. All right, so you've got...
Question that side.
Yes, sir.
Hi. So you do this level of review in your office to decide whether or not an officer may go on the Giglio list. What do you do if you have a line deputy who's aware of the same facts, and that line deputy thinks that there is a Giglio issue, but the committee or panel or whatever it is you're using decides that they're not on the list? How do you handle that scenario?
I guess the simple answer is that you're in the Army now, and you don't get to make an individual decision on that. You can bring it up with the committee that decides that, but there has to be uniformity. And just like the judge, the Supreme Court says, they're not last because they're always right because they're last. Somebody has to make a decision at the end of the day that yes, this does constitute Giglio for this office, or it does not. And once you have made that decision, then your deputies and your line assistants are going to have to follow it. You as DA are going to have to stand it up. In other words, that comes back to you. If somebody then raises a complaint and says, you're wrong about that, you better be ready to make your arguments about it. That is, as John and Nikki talked about, the danger of being a DA these days, which is anybody, anywhere, can start throwing around accusations, and next thing you know, you're getting sued about it. All right? I've been sued on Giglio, and it happens. It hasn't come from my own office. My own office has reached agreement after discussions on these things. But I could see, and that's a good question, is if a line assistant disagrees, then they're going to have a discussion with you about it.
I guess I mean specifically a line deputy prosecuting a case where that officer is at issue. I'm from California. We have different rules, but I mean, is there any room for that line deputy to say, look, the panel reached its decision, but I'm looking at it and I think it's Giglio or I think something's Brady? Is there any room for that person to disclose it anyway, or is that
we generally say no, but I can see that is an interesting issue that I'm going to have to spend a lot more time thinking about. Like I said at the start of this, I come in here and I want to hear some different things, and that's something I'm going to have to think about. Nobody raised that during all of our discussions, but that's a great question. Yes, sir.
So question, so there's a new, let's call it a philosophy of investigations, sometimes referred to as start by believing, sometimes referred to as trauma-informed, but fundamentally this is all about intentionally biasing the detective's investigation to favor the complainant's account. So I don't know if you've come across this in your jurisdiction, but there's a lot of places in the country where this is widespread. Do you have any opinion whether this falls as Giglio material?
So the question was, if you're doing trauma-informed, believe the accuser up front, believe their story no matter what, and start it with that general approach, does that impact on Giglio? From our perspective, no, because that is a philosophical approach and a strategic approach to investigating cases. We have other officers who take the approach that they disbelieve everybody up front, and that's reflected in their reports, and that's a strategic choice by them. That's not an intentional lie. That is a strategic choice in how you're going to go about your investigation. So we haven't run into that yet. Yes, sir.
with respect to the gentleman from California's issue, nothing would preclude you from notifying defense counsel that we looked at this for Giglio and decided that it didn't warrant it, but just out of an abundance of caution, we're letting you know that this is what the allegation was.
Could do that, although you also run into the problem then of you might get sued in Pennsylvania for infringing upon the reputational rights of that officer.
Even if you caption in very non-committal terms?
Even if.
And express your opinion that in fact you don't believe it's credible, but you want, anyway, I'm just.
No, I'm just saying that you could get sued for infringing on the reputational rights of the officer. I'm not saying the suit will work. I'm just saying that that's what you're going to get sued for. Yes, sir.
Wouldn't you have, wouldn't immunity apply in that situation? Would a DA or DA's office actually be subject to sue something?
So you would, in Pennsylvania, what you would get is you would have immunity from any of the potential monetary damages, but you would not have immunity from a finding that you had violated the reputational rights and being ordered not to do it again, and to actually strike whatever you had said or whatever the injunctive relief they were looking for. So now we're starting to get down to the weeds, so let's not get too far into the weeds, but those are good questions. Yep.
Unless we're still enrolled, I don't know.
No, go ahead.
You mentioned that your office, your DA's office, has open file discovery, and it's resulted in 0 Brady violations since you've had it.
Right.
But that there were a few coming out of the police department. Considering that we all agree that Brady applies to the police department equally as a matter of law, would you recommend that police departments also go to open file?
In Pennsylvania, you can't, because there's a law called Korea that says you can't share raw law enforcement information. And there's a good reason that you can't share raw law enforcement information.
So even we can account for some of that, we can create some sealing, we can create some redactions, but as a general matter, can we overturn this law where it matters and have police be just as open as you are?
I will be happy to discuss that with you outside, but that's taking us away from Giglio.
Sure. Well, okay. No, go ahead.
I have a question about the retroactive nature of it. So
Sure.
In my district, we had 2 instances that have kind of created issues. One was an officer who was on duty, or was working for about 2 years in one of our cities, and he would go home during his shift, and it was really some boneheaded stuff. But he ended up getting fired, and it ended up being a Giglio issue because a judge in the case said it came out one way or another on cross, and this officer had lied to his superior officers repeatedly. He'd been fired for it. So the judge ordered us to, and this was before I was district attorney, but the judge ordered us to basically pull every file to see, which I thought was a good idea. And the second issue that we ran across was before I was district attorney, there was a police shooting. An 18-year-old boy was killed by a police officer. And in our state, the Attorney General's office investigates, and the police officer was believed, and the physical evidence didn't match the statement of the police officer. So it was a justified homicide, as all police-involved homicides and shootings have always been in the state of Maine. And then throughout the years after, he was convicted. He was charged multiple times with felonies, with violent crimes, with misdemeanors, and there were other issues came about. So the retroactive nature. Have you dealt with this? What you do when?
Yes. If you lied at some point,
every case you're involved in needs to be investigated.
Giglio goes both ways. There is no statute of limitations on Giglio. Giglio lasts forever. If we ever find out about it, it goes on. And it doesn't disappear at some point in the future.
So do you have a conviction integrity unit, or what?
We do have a conviction integrity unit. Nobody's ever accessed it. All right? Our whole system, and this is a whole different category, our whole system is set up to be a check all along the way on the integrity of our cases. So we have just not had a problem with that because it gets checked. When it gets charged, it gets checked at the preliminary hearing, it gets checked in major case, it gets checked by the line prosecutor, it gets checked by their supervisor, it gets checked all the way up. We have so many systems in place that we have not had to activate it. But yeah, we would take that into consideration. But Giglio stretches in both directions. Now, the reason we initially had just a do not use list, the reason that we actually segregated it out into a use with disclosures list was we came into circumstances which are not uncommon, which is a judge makes a finding during the course of a suppression hearing or a trial that an officer, that their testimony was lacking in credibility. And we have gone back and we've had to review some of those with the officers, and it turns out that when we reviewed it, no, the officer told the complete truth, and the judge just got confused, or the judge wanted to throw the case out for some reason, and finding an officer's credibility lacking is an easy way for a judge to throw a case out, because you really can't appeal that. So in that case, do we have to list it in our GIGLIO disclosures list? Absolutely. It's a finding against credibility. Do we then argue vigorously that the police officer was honest, that the judge made an error, and this absolutely should not come into the trial? Absolutely. So here, those are some of the human things you need to take account of during GIGLIO. All right. John is starting to wave at me to go faster, so I'm going to go faster. All right, so you've got your mandatory disclosures list, you've got your notification, notify the officer and the chief in writing. We also found we had to do that because the chief did not always, when we told them somebody was on the GIGLIO list, did not always tell the officer, and the officer found out later. That's not a good thing. That's why we notified both at the same time. So a couple of miscellaneous points then. One is, do we reconsider? We do. That's why I have the first assistant do it, as I said, so that if there's a reconsideration, it can come into me as the DA and I can look at it again. Is there an appeal? There is. Why is there an appeal? Because 2 or 3 years down the road, you may look at something and say enough time has passed and somebody can drop from do not use down to use with caution. They're never going to come off of the GIGLIO list because, as we just talked about, there is no statute of limitations on GIGLIO. It lasts forever. Why do you create a review, a reconsideration and an appeal? Well, one, because it's fair, right? Everyone should have a chance to get looked at again. 2, because this is considered due process. And when you get sued for your GIGLIO procedures, you want to be able to point to them and say, there's due process in it. So a practical consideration and an ethical consideration. All right, you've got to make clear that the internal affairs and the arbitration decisions are entirely separate from your GIGLIO list. Yes, you'll look at what comes out of them, but an arbitrator may say he's perfectly fine to go back to work, and you may say that may be, but he's not being called as a witness by me. So make that clear in your written policy that they are totally separate issues. Public disclosure of the GIGLIO list. Should it be publicly disclosed?
Of course.
That's right.
We would oppose public disclosure.
Can you tell us why?
Sure. Such a list is really relevant only in the context of a case or cases, because it is used for a specific purpose, and that is whether to call somebody or whether to cross-examine them, or et cetera, et cetera. As we've already talked about for the last hour, there are things that are outside the line of duty. There are personal matters that might get somebody on the list, but it's now we're talking about reputational harm in the broader community. So to distinguish it from Megan's Law, when Megan's Law you have a sex offender who goes back into the community and other people should know about it, the fact that a police officer might have lied in one instance about something doesn't harm the community that surrounds him in terms of where he lives, and there's no need to affect somebody in that regard.
And I'll just add, the ACLU should appreciate the concern that some of these placements are based on speech that people are determining involve bias, but it could be protected.
Okay. So, how many of you think there should be a public list of everyone who's on GIGLIO? How many of you think there absolutely should not be a public list? All right, there's a real split, and that really reflects the split that we are seeing. And in our discussions within our DAs, here's where we came out. Our constitutional duty is to turn it over to defendants. We are going to comply with that constitutional duty no matter what. Whether or not that list should become a public list is a matter for the legislature to determine. The legislature needs to take that up, listen to the will of the people, and decide what should happen there. That is the difference between the judicial, the executive, and the legislative branch. Not up to us. Now, I can tell you, in every case where it has gone up in front of a state Supreme Court, they have said it's going public. So you can expect that may happen. The other thing that you need to think about is these officers move around. And we have a classic example in Pennsylvania of officers in the eastern portion of the state getting on a GIGLIO list and then disappearing and showing up in the western portion, and nobody knows they're on the list. So at the very least, I would say, this is just a personal opinion, there should be at least a law enforcement database they can check and find out if somebody is on the GIGLIO list. The bigger question, that's up to the legislature, that's beyond me. All right, I'll finish up with the union push. The union push, they didn't want a list to exist, they just wanted it to be in the prosecutor's head. We told them that that was nuts. You have thousands of cases and thousands of officers. That's not going to work. And what happens when, as just happened in Pennsylvania, 20 out of the 67 DAs did not get reelected, and you have a new DA coming in. So we told them that wasn't going to work. No do not use list except for criminals was what the State Troopers Association said. Everyone else should just be on the disclosure list. He said, 1 lie, 2 lies, 3 lies. How many lies before they get on the do not use list? They said they don't care. That's just disclosures. He said that doesn't work for prosecutors. And here's where we really got into a head-banging match. Who should decide who's on the GIGLIO list? Abraham Lincoln or the clown? From the standpoint of prosecutors, we're pretty sure that we're Abraham Lincoln and that we should decide. That's what we were elected to do. From the union's perspective, we are the clown, and they don't trust us. And that's really where the rubber meets the road. The suggestions from the union were, first, that it go into arbitration, and we all know how successful arbitration has been. The next one was that since we report to the president judge should decide. You should have seen 7 prosecutors coming across the table at the union lawyer and trying to throttle them, saying, we don't report to the president judge, all right? Did you miss that part of class where they explain the difference between the judiciary and the executive function? We're the executive function. But these are some of the suggestions we're getting. So I'll wrap up with this.
By the way, I only work for some unions.
GIGLIO is complex. It's evolving. We don't have a case that says here's what GIGLIO is and here's what GIGLIO is not, so we're going to have to work through that. You need to have a written protocol in place, though. USA Today just did a story 2 weeks ago. Less than 50% of the prosecutors in the United States have a GIGLIO protocol. They are mocking us and making fun of us. You've got to have a GIGLIO protocol in place. And it is your duty as prosecutors. It's your constitutional duty. It's your ethical duty. It's your duty to the people that you represent to make sure that honest testimony is presented. And it's your duty to the good police officers. The good police officers want to know that they are trusted. And they hate a dishonest police officer. All right. Thank you very much. It's been my pleasure. And a big hand for our panelists who did a great job.